Chairman, President Robinson, ladies and gentlemen. One of the ironies of history is that small states have played such an important role in enhancing the international legal order. You may wonder why this is so. You know, Africans have a statement. When elephants fight, or for that matter, play, the grass underfoot suffers. The small states in the international community are the grass underfoot. And we, therefore, have a primordial interest in the rule of law in the international community, which, from time to time, we get the impression is totally absent. The creation of the ICC was, in fact, a bold initiative in expanding the frontiers of international human rights law and international humanitarian law. But, however, the ICC, to my mind, has some shortcomings which hopefully in the future these will be addressed and corrected. You all know of the regime of the oceans, which was also spearheaded by a small state in the international community, Malta. What you have not known about, I suspect, is the role recently played by the little states of CARICOM in creating what you may call the most innovative international judicial institution in the world. And I think that the ICC can take a leaf out of the book of the Caribbean Court of Justice, on whose benches I sit. We have a court where the shadow of the state is not as dark as that which languishes on the ICC. We have a court whose institutional and individual independence is beyond question, whose funding is on a sustainable, independent basis, whose judges are not selected by the political surrogates of this world. We have open competition in the Caribbean Court of Justice for judgeships. Vacancies are advertised. The candidates are interviewed by an independent regional judicial and legal services commission. On the basis of performance, judges are selected. Funding of the court is achieved through a trust fund, where the CDB of the region was authorized to go out in the international capital markets, raise a loan of $100 million US, which was on lent to the small state of CARICOM, who did not see that money. It was put in the hands of trustees, the proceeds of which run the Caribbean Court of Justice. The judges of the court are not appointed by political surrogates. The only exception in this context is with respect to the president of the court, who must be elected by the heads of the government in a qualified vote on the recommendation of the Independent Services Commission. In our court, the shadow of the state is not so large, and the independence of its judges is beyond question. Now, if you compare this with the ICC, there are, I think, some troubling aspects of its composition and its administration. Now, for one thing, judges have to be sponsored by their states of nationality. And here there could be questions concerning their individual independence. They must also be elected by political surrogates. And here again, one may be able to question the independence of judges. Funding for the ICC is provided by states, parties into the regime. And you know exactly what that means. It means the states with economic clout will be those which could, in the ultimate analysis, influence the determination of the ICC. One of the more troubling aspects of the ICC, in my respectful submission, is the role of states in the administration of the court. You'll find it in Article 1112. The states exercise management supervision over the administration of the court. And in Article 1114 of that statute, the states are also entitled to create a watchdog committee to investigate, inspect, and evaluate the administration of the court. We all know what the rule of law, as we understand it, entails. It entails, first and foremost, that the powers of governance are shared between the executive, the legislature, and the judiciary, all more or less acting independently. In a situation, therefore, where states, entities in the exercise of their executive competence and can have oversight of the administration of a court, one will need to question the independence of such a court and the integrity of its institutional relationships. These, I think, are troubling aspects of the International Criminal Code which should be advanced, which should be looked at in future developments of the court. And I am saying this not out of a lack of appreciation for the commendable achievements made in the establishment of the International Criminal Court. It clearly has enlarged the perspectives of international justice. It has clearly led to the investigation, prosecution, and conviction of perpetrators of some of the most heinous international crimes. And certainly, it has led to the relegation of immunity to the rubbish heap of history. But in spite of its achievements, I respectfully submit there is room for improvement, and I trust that with time, such improvement will be made. Thank you very much.